My name is Regina Hopkins. I'm with the DC Bar Pro Bono Center, and welcome to our webinar today on exempt or non-exempt. That is the question, the discussion of who is subject to overtime regulations and who is not. We are joined here today by Sadina Montani, who is an attorney with the law firm of Vedder Price. Sadina is an expert on employment law matters and counsels many nonprofits about the laws in this area, and has conducted many webinars for us on this topic. So just a couple of things, housecleaning things. The presentation is, if you look at the interface for the webinar, there is a presentation of the PowerPoint that you can download. It's the PDF, so feel free to do that. There's also a question box where you can type in your questions, and we will pause at certain points so that you can ask them, and we'll convey them to Sadina, and then she will answer them for you. So with that, I turn it over to Sadina and say thank you so much for your time today, and we appreciate listening to you. Thank you.
Well, good afternoon, everyone. As Regina mentioned, I'm Sadina Montani. I'm with Vedder Price, and as Regina mentioned, a large part of my practice is dealing with nonprofits and their employment issues, both in the pro bono space and also as the more traditional paying clients. But I work with a lot of nonprofits, and a lot of the issues that we're going to talk about today are ones that are especially challenging for nonprofits and other small employers that are dealing with challenging, small workforces and trying to navigate these areas, particularly in light of the fact that many times many of your employees are wearing multiple hats, and figuring out how this impacts your workforce is challenging. I will say that this area of the law is challenging for all employers. It's a big part of my practice to deal with wage and hour audits, to look at various positions that employers large and small have, and to determine whether positions fit within the overtime exemptions, and then to litigate when things have not gone perhaps as smoothly as we would like them to. So the plan for today's webinar is to start with some basics regarding the FLSA, the Fair Labor Standards Act, which is the federal law that covers overtime eligibility for certain employees. I will note that there are certain state laws that also impact the analysis we're going to talk about. Throughout the presentation, I will flag when appropriate where state laws are different. I will add a caveat that if we have anyone who has any employees in California, that's a whole separate can of worms, generally in the employment space, but also in terms of these regulations. They're also much more complicated for California, and would pretty much require a half-day seminar just on that topic. But I will give you enough information to hopefully not scare you too much, but to really understand where the differences are in state laws. So I won't spend a lot of time today on that overview and the kind of basics of the FLSA, because I assume that most folks have a pretty good understanding of that, but I wanted to at least provide an overview so that we're all on the same page. And then the bulk of today's presentation will be speaking to the various overtime exemptions and what you should be looking for when you're trying to determine whether a specific job position qualifies for an exemption, and what the mistakes are that I often see with employers who are either at the point of conducting a wage and hour audit and trying to figure out if they are compliant with the FLSA or the state laws, and then later on in litigation. So with that, let's dive right into the overview. So who is covered by the FLSA? I have a slide here that mimics the language in the regulation. The last line really is the key here, and I don't mean to be too cute, but basically anyone who works and has a pulse is going to be covered by the FLSA. So to the extent you think you may not be covered, that's very, very unlikely, and it's the case that you should certainly operate from the default assumption that your employees are covered by the FLSA. It applies to all employees of a covered employer. There are some very, very limited exceptions for nonprofits that I think will be on a separate slide. I'll go ahead and mention them while I've got it top of mind. But there are certain exemptions for nonprofit employers who do not engage in interstate commerce. That used to be a much more meaningful exemption before, say, Amazon, because to the extent that you have anyone who is ordering your office supplies on Amazon, for example, or taking donations from someone outside of your jurisdiction, that transforms you from a separate exempt nonprofit into a nonprofit that's covered by this. So I have, in my decade or so of practice, never actually come across a nonprofit that has not been covered by the FLSA. I mention it only because that is a question that often comes up, particularly when I'm speaking with nonprofits. So I think going into it, we should all operate under the assumption that nonprofits are going to be covered by the FLSA. Person, I have the statutory language here. What does it mean to control a person such that they're your employee? That's what this really is speaking to. Again, we aren't probably dealing with any employers here who have employees who are kind of in that strange space where they're potentially employees for multiple employers, and I won't get too far into the weeds, but I wanted to provide, again, this statutory language so you have it in the materials and you can take it with you. Okay, so let's start to get into the meat of what actually is covered by the FLSA. What's covered is any work that, and this is again very old language, an employee is suffered or permitted to work. That's a very interesting way of describing what we do on a daily basis, right? Going to work and suffering. But that commentary aside, any work that is performed, even if it's not requested, must be paid. So, for example, if you have an employee who stays late, they don't ask for permission to do so, they end up working 45 hours in a given week, you only find out about it when they submit their timesheets, you still need to pay that time. Separately, of course, you can have policies in place that require that an employee request and obtain pre-approval before they work overtime. But even if you have that policy in place and the employee fails to get permission and works those extra hours, you still need to pay them. You can discipline them separately for the fact that they've failed to follow that policy, but anytime an employee is performing work, they need to be compensated for it, except for those employees who are exempt from the overtime regs. That'll be the stuff that we cover in just a few minutes. To the extent that anyone on the webinar has folks who are on call, I'll just mention briefly that if someone is generally on call but can go about their daily business, they need not be compensated. But if someone is on call and has to stay, for example, within 10 miles of a specific location or is otherwise restricted from engaging in their daily life activities, that potentially could be compensable. A few decades ago.
Sure. Before you go on, and I apologize for the background noise. We have someone unloading something in the background here. So if people can hear it, I apologize. You mentioned on the slide, and I think it may be, maybe if you could spend a moment talking about what happens if you text an employee or email them over the weekend or whatever. And sometimes these go back and forth, 3 or 4 rounds or something like that, and a lot of people, do that, without really sort of reflexively thinking it. Can you talk a little bit about that and what employers can do to, like, A, train supervisors, or B, to say, don't text your non-exempt employees unless the building's burning down, some sort of thing, or just even whether you let non-exempt employees have access to their accounts during off hours, because I know a lot of people get tripped up on stuff like that.
I absolutely can speak to that, and at some point you may have to cut me off because I could probably speak for the whole hour on this because it's so rife with opportunity to get into problems. There's a couple big points that I want to make. First of all, you're right, Regina. It's important to make sure that your supervisors are trained because the issue when we're talking about if an employee is doing work and the employer knows about it, right, so that they have to pay the employee, even if the employee, for example, is not putting any extra time on a timesheet, but the employer knows that the employee is working those extra hours, they're liable for that work. So what that means when we're talking about having access to email and texting and all of those things after hours is that your organization, if it knows employees are engaging in work, needs to pay it. Your organization means not just the executive director of your nonprofit, not just your COO. It means your managers as well. So if you have managers who are reaching out to employees, asking them to do work, asking them to respond substantively to texts or to emails after hours, even if that employee is not putting that time on a timesheet, if it comes out later, if they come back either in, if there's an audit or if there is litigation and they are trying to get that time, you definitely will be liable for that because you as an organization through your managers knew that they were performing that work. So training managers is incredibly important. Depending on the needs of your business, it may be the case that you really do need all of your employees to have access to their work email on their smartphone or to be able to log into it remotely. If you do that, you really should have pretty specific policies in place in addition to training your managers so that you are making clear, when employees, if they are required to check their work email after hours, if there is a requirement that they do that, if you can deal with it on a case-by-case basis. What I'll say is that generally I advise very strongly against allowing non-exempt employees to have their email on their smartphone. I think that it's untenable. Particularly, this is very relevant, right, especially what they're dealing with in Florida right now and what they've been dealing with in Texas. There's obviously going to be a lot of folks for whom working in the office is not going to be an option. Transportation, the offices may be closed, but operations still need to go on. In those cases, and for that reason, it's useful for you to have a system through which employees can log in remotely, but you should not be requiring them to do that on a daily basis or over the weekends unless there's a specific business need. And there certainly are some non-exempt employees who need to be available nights and weekends to deal with issues when they're outside of the office, and that's fine. But if those employees are doing any substantive work, anything that rises above the level of what the statute calls de minimis, that's work that needs to be compensable, and they need to be reporting and tracking that time, and you need to be paying them for that time. Not to get off on too much of a tangent, but in terms of what constitutes de minimis, there's obviously volumes of case law on that point. But generally speaking, if you're sending someone a text that says, a non-exempt employee text that says, hi, so-and-so called out sick tomorrow, would you be able to come in an hour early to help cover their work, and they say yes or no, that's not really going to be compensable. It's a very short amount of time, less than a minute, obviously, to get to that answer, and it's also not substantive, but it is the case that you can very quickly get in a situation where, a manager and a non-exempt employee are exchanging emails about even where are the copies to this? I'm trying to find this file. Do you know where it might be located? Did this get sent out today? Those sorts of things back and forth that could, first of all, take a fair amount of time for the non-exempt employee to answer, and also obviously would be substantive and for the benefit of the employer. So those are kind of some initial thoughts about that. I don't want to, as I said, I could speak about that for quite some time, but it's incredibly, incredibly dangerous, and it definitely is important for you to have policies in place that govern that, make sure that people track their time, and that your managers are trained on the point that they should not be texting non-exempt employees or sending them emails and expecting them to respond on off hours unless they're planning on paying for that time. Was that helpful, Regina?
Yes, thank you. I'm sorry, I had it on mute
Okay.
because of the background noise. I apologize.
Okay.
Thank you.
No problem. No problem. All right. So I'll go ahead and move on. Just to mention very briefly, when the FLSA was first passed, there was some question as to whether going to and from work would be compensable, because commuting is fundamentally for the benefit of your employer, right? To show up at the office is for the benefit of the employer. And to harken back to that suffer term, most of us do suffer through our commutes. So early on, I think initially in the 70s, the FLSA, the Portal to Portal Act was enacted to clarify that no, commuting time is not compensable. I mention it because if you have employees who are moving between various locations, so let's say, for example, you are an employer that has a number of clinics or facilities throughout the city, if the time that an employee spends reporting in the morning to Clinic A, where they're doing some number of tasks and therefore some number of hours, if they're then required to go to another facility or clinic or what have you elsewhere in the area during the workday, the time that they're spending traveling from Clinic A to Clinic B, that definitely would be compensable. It's just that then at the end of the day, when their workday is over, the time spent going home would not be. Okay, so generally, just a note on rest periods. They're generally paid working time. There's not real rigid requirements under the federal law about rest and meal breaks. As a best practice, giving folks a rest break in the morning and the afternoon, allowing them to step outside to go get some coffee, that sort of thing, is a good practice to have. If for no other reason than mental health. Obviously, most folks have a paid or unpaid meal break. This is one area that I'll note that if you're in California, and I'm working on a class action in California on this very issue right now, you need to make sure that folks are getting uninterrupted rest and meal breaks at very specific times during the day. And if they don't, for example, get their unpaid meal break before the I always get it confused whether it's 5th or 6th hour of work, they not only need to have that meal break, but then they get paid an hour of overtime for it. So there are penalties, and if you miss those, it's quite a quagmire. So if you're in California, note that the rest and meal break issue is different.
Before you move off of mealtime, Sadina, can I ask one other question?
Absolutely.
Okay, so the people who eat lunch at their desk.
Yes.
And so they're just sitting there and the phone rings, or you come up and talk to them or something like that and say, oh, by the way, can you do this or that, or can you find this? I mean, they're technically, well, they're not technically at lunch. They're technically working, but they're viewed as being at lunch. So could you explain a little bit about, what do you do for someone who's working at their desk and they're approached or asked questions about work?
Right. So that's a great point, and I've had a number of lawsuits that do with that very question, where people do choose to eat at their desk and they are clocked out for that time, so they're not being paid for it, but then they're being asked to do work. A lot of times it does not necessarily come. It comes from a place, in my experience, generally from a lack of education on the manager's part. So I'm glad that you raised this issue. If someone is interrupted from their unpaid break, just the same way as if they're called after hours to answer a question, they need to be paid for that time. So there are a couple ways that you can handle it. You should have a policy in place that makes clear that if people do perform work during their lunch break, they need to track that time, clock in or clock back out, or however your HR tracking system is set up, or manually let HR know that they worked a certain amount of extra time. One thing that a number of my employers have started doing is actually and to be honest, we do this at my law firm, when folks are at lunch, but they're at their, for example, our support team, our paralegals, if they're at lunch, they actually have signs on their work, like the kind of platform that's above their cubicles, and everyone has signs that say at lunch. And that way, if you're walking up to someone's workspace and they're at lunch, but they're sitting there, you can, as a manager, oh, well, they're at lunch. Let me know when you're back. I have something to talk to you about. It seems a little silly, but it's proven very effective here, and I've advised a number of my clients to do that very same thing. You know, part of it is that if folks are taking an hour unpaid lunch, it may be the case that they go out, they grab some food, they eat outside, they come back and they want to, you know, do some online shopping, or they're otherwise just at their desk. They're not even obviously eating or on a meal break, and it's very hard to know. And sometimes employees don't feel comfortable saying, I actually can't do that for you right now because I'm on my break, or I'm at lunch right now. So that the sign is a good kind of non-confrontational way to do that. But I raise that to note that the training and the policies you need to have on this front are not just for managers to know that they shouldn't be interrupting people when they're on their unpaid meal break, but also for employees to know that if they're on their lunch break and someone asks them to do work, they absolutely should and are entitled to and should not feel any concern or retaliation for saying, I'm actually at lunch right now and I can't do that for you. So figuring out logistically what works for your workplace, but also having training and policies in place to make sure that, that everyone's aware that no one should be doing work on their unpaid meal break.
Thank you.
Absolutely. Very briefly, I mentioned that, and this is, I think, an issue that comes up more with my DC employers, to be honest, than in other regions, perhaps because we're all a bunch of type A nerds and we all want to, you know, be go-getters here. But to the extent that you have employees who are going to trainings or going to seminars or conferences or those sorts of things, they generally do need to be paid. So if they're going to a conference that's, you know, on a Tuesday afternoon down K Street or wherever the case may be, if that's part of their workday, then they need to be paid for it. There are pretty limited exceptions to when they should not be compensated for it. They're listed here, and I'll just leave this here for you all as references, but just to note that as the default, you should assume, generally speaking, that if you have employees going to training or lectures, those sorts of things, they should be paid for that time. So here I have obviously the general statement that employees who are not exempt from overtime should be paid time and a half for all hours worked over 40. I'll flag again, there are different state laws here. California obviously is one of them. In California, if you work more than 8 hours in a day, for example, you need to be paid overtime if you're non-exempt. The second bullet here is one that I think is news to most folks when they're thinking about this, and I really want to emphasize this and urge you to keep this in mind as we're working through the various exemptions, and that is that the default should be that every employee is paid overtime unless they are exempt. So I know it's often the case when we're doing when I'm doing wage and hour audits that I'm working with employers and they say, well, I want you to explain to me why this person is non-exempt. That's actually not the question. The question is that we need to be proving that the person is exempt. So it's just a difference in the perspective and what question you're asking. The assumption is not that everyone is exempt. The assumption is that they're non-exempt, and then for all the reasons we'll talk about in a few moments, they have to meet requirements in order for them to be exempt and not do overtime. Here I just have, as I noted before, different state-specific requirements. There are, I think that it's the case, and we aren't going to talk too much about kind of the politics of what's going on with the Department of Labor and the overtime regulations. I think that between Regina and I, we could speak for literally the entire day about this topic. But note that, as many of you probably have heard, the regulations that went into or were supposed to go into effect last fall that raised the exemption salary threshold from $23,000 and some change to $47,000 and some change were enjoined. They did not go into effect. Now they have been struck down, and there's all sorts of legal wrangling, but the long and the short of it is that they're dead, and we may likely get new regulations that raise the threshold somewhat, probably into the mid-30s, which is not particularly meaningful, particularly in this area and given the market rates for labor in the DC area. But I think in the wake of that, we are likely to see an increase in states instituting regulations on a whole host of employment fronts, That's been something that we've seen across the board. But I think particularly in the wage and hour area, California is in the process of raising their threshold. They already have an increased threshold, for example, for the computer professional exemption. Illinois and New York likely will do the same. So just keep your ears open. If you have employees in other states, you really need to be keeping an eye on what's happening on the legislative front in all of those states as states step in and legislate in ways that the federal government is not doing. Just a couple of nuts and bolts issues here that you, as an employer, you are certainly free to choose the date and the hour that the work week starts. Most employers are, Sunday to Saturday or Monday to Sunday. What you're not allowed to do is to shift it around as you go to avoid paying overtime. I doubt that anyone on this call would do that, but I would be remiss if I didn't mention that you were not allowed to do that. Also an error that I sometimes see employers, small employers making is the idea that you can consider the overtime analysis over a pay period, so a 2-week period as opposed to week by week. So they have said, well, as long as you're not over 80 hours in this 2-week period, then that's fine, and I don't have to pay this employee overtime. It's not the case. Whether you pay the employee weekly, biweekly, every third day, whatever the case may be, that is irrelevant to an FLSA overtime analysis. So in terms of what is included for the overtime calculation, this is an issue that gets very, very complicated, but suffice to say that you do not need to pay overtime for someone if they take sick leave or vacation leave or personal leave. So if they take off Monday, they use 7.5 hours of leave for that. They end up working 4 hours extra on Thursday, and so their total hours are more than 40, but some of those hours were leave and they did not work, then you do not have to pay them overtime for that. Also worth mentioning that by and large, any additional wages that are not just their hourly rate, if they're getting commissions, if they're getting some kind of additional like piecework earnings, that often happens with more blue-collar employers. Anything that's non-discretionary bonus, and again, what constitutes a discretionary and non-discretionary bonus is a bit complicated, but essentially you should operate from the assumption that if you're paying someone not just an hourly wage, but some additional type of pay, that needs to be included for purposes of calculating what 1.5 their hourly rate is for overtime pay. Important here.
One question. One question. So what about salaried employees? I know people sometimes confuse the two. They think that it's between hourly and salaried, but it's really exempt versus non-exempt. So you can be a non-exempt person and be paid on a salary basis, correct?
That is absolutely correct. That's absolutely correct. And that's often something that comes up when I'm working with employers and they realize they've misclassified someone and they need to transition them from an exempt position to a non-exempt position, but they don't want to. I mean, we've gotten to a point in our society where we assume that if you're salaried, that means something, right? And to take someone away from being salaried and making them punch a clock and be an hourly employee can seem like a demotion or an insult. One of the ways that you can soften that blow is to keep them as an exempt employee. That said, you'll still need to calculate what their hourly rate would be, but you can pay them on a salaried basis, and then just make sure that you know kind of on the back end, nuts and bolts HR side, what their salary breaks out to on an hourly basis, so that they can be paid overtime if that's necessary. It will require them, of course, to track their time, so there is that piece of it, but you absolutely can have a non-exempt employee who is paid on a salary basis, and you can communicate to them that that's their wage, but then additionally that they're eligible for overtime.
And you calculate their regular rate by just the math of you work 40 hours and you get paid this amount, so this amount divided by 40 is your hourly rate for overtime.
That's correct. Yeah, that's correct.
Okay, thank you.
Absolutely. I mentioned here that an employee can't waive the right to receive overtime for a couple reasons. First of all, if the employee says, oh, no, I just want to stay for this extra hour to get this done. I'm not going to track my time. I really need to get this done because I work for a nonprofit and I feel very strongly about the cause and I'm dedicated to my work. As an employer, you cannot say, okay, you have to pay them for that work. That's important. Another point I want to mention is that if you ever are in a situation where you have a dispute with an employee about their overtime wages, you can't actually just pay them and have them sign a release and the risk of litigation goes away. You can pay them and have them sign something that says, you know, I believe this is all the money I'm entitled to, but they still would have a right to sue you, so you can't get a traditional release for disputes around overtime pay in the same way that you can for age discrimination or gender discrimination or harassment or any of those things, which I think that most employers, especially small employers, are not aware of. They actually have to be approved by the Department of Labor, which is a whole process. So just to flag that, so it's something that is floating around in the back of everyone's head if they have a sticky situation come up.
One other thing, if you could touch on briefly, you see it a lot. I know the government can do it; they're legally allowed to. But in fact, I had a conversation yesterday with someone. Well, we give them toil. What's toil? And they said time off in lieu of overtime. If you're a non-exempt employee, can you say, I won't pay you overtime, but I will give you time off?
Right, comp time. I think that I actually maybe just started developing hives as soon as you started asking me that question. Because it seems like a fair thing, and we know the government can do it. And so it seems really harsh that the government can do it and employers cannot. But you're right, employers cannot give folks comp time in lieu of overtime pay. I will add one caveat here, is that keep in mind that the overtime analysis is whether an employee has worked more than 40 hours in a single week. So what you can do within a single week is adjust the employee's schedule so that they don't go over 40 hours. So for example, if you have a big fundraising gala that your nonprofit has every year, and it is on a Tuesday night, and so for that Tuesday, you know, it's all hands on deck, right? Everyone is in the office at 8 o'clock, and they are at the event until 10 o'clock, and it is a long slog and a terrible day, and suddenly you have people who have worked 14 hours in a single day, and that would be a whole lot of overtime pay if you had to pay it. So what can you do? You can't give them comp time, but you can cut time off the rest of their hours for the remaining week, right? So if they've worked 7 extra hours on Tuesday, you can say, don't come in on Friday, or take half days for the rest of the week. You can adjust things so that the math works out that at the end of the week, they have not worked more than 40 hours, which is a little like comp time, but it has to be within that 40-week period. So I would not call it comp time. I would, you know, you can be flexible with scheduling. If you have a policy in your handbook that includes comp time, please take it out, and please stop doing that and replace it with kind of a guidance around flexible scheduling when, you know, special circumstances exist and you need to adjust schedules within that 40-hour work week.
Thanks.
Okay, I'm going to take a drink of water and then we'll move into the misclassification issues. Okay, so I have, these are the 6 there's a couple of very random exemptions which, you know, apply to truck drivers and I'm sure not applicable to the employers we have on the call today. These are the 6 main exemptions, and I have them prioritized with the first 2 being the exemptions that I would say 80% of employees are thrown into those buckets, and those are the ones that are the most ripe for error and litigation. One of the things I have been saying this for years, and so I apologize if anyone else is on the call has heard me say this before, but when the Department of Labor was in the process in the Obama administration of looking at the regulations for the FLSA and thinking about how they might change them, the one I was constantly saying if they did one thing, I wanted them to change the name of the administrative exemption, because when that exemption was rolled out in the 70s, administrative meant something different in our standard office parlance than it does now, and it's just a total misnomer, and it is really ripe for error. So my focus for the next few minutes will really be on the executive and administrative exemptions, because those are the ones that are most ripe for error, but we'll also speak to these other four to make sure that folks understand those as well. So the requirements for the executive exemption, the first is that they're paid a salary. You can't pay them hourly. You have to pay them on a salary basis, and it has to be at least $450 per week. This is the piece that the regulations that are now dead were going to increase, so that threshold is going to be substantially higher. Again, it likely will be increased at some point over the next few years, but right now it remains at $455 per week. Their primary duty has to be managing the company or managing individuals, and it has to be 2 or more full-time employees or their equivalents. If you have someone who's managing 7 part-time employees or even 4 part-time employees, but they add up to 2 full-time employees, that works. I have a number of things emphasized here. The first is primary duty. So what does that mean? If we were in California, there actually is a bright line rule that it would be 50% of their time is spent managing the company. There also was some speculation in years past that the regulations would be updated to track that more clear guidance in terms of what primary duty means. When I'm doing a wage and hour audit, I typically like to see that an employee is doing 40 to 50% of their time at least is managing the company, a subdivision, or these individuals, because otherwise they may not qualify for the executive exemption. In terms of what management means of individuals, they have to be, if not fully in charge of, because obviously we have checks in HR, but they have to have really significant authority over hiring and firing and disciplining and those sorts of things. It can't just be someone who's setting a schedule, who's generally supervising. It has to actually be work as a manager. So here are the common mistakes that I often see, and there has been on this first one just a ton of litigation about, in the retail space and also in the restaurant space, whether assistant managers are actually qualifying for the executive exemption. So typically they don't if they are only, setting store schedules and making sure that folks are taking their breaks on time and really just handling the day-to-day operations, but actually not involved in the management and control and oversight of the work that the employees, the subordinate employees, are doing. If they don't have any authority to discipline, to recommend termination, those sorts of things, they're probably not going to rise to the level of meeting the executive exemption. Team leaders, that's another, depending on the type of employment situation you have, that's another job title that I've seen that often gets thrown into the bucket of managers because they're doing manager type work, but they're not actually managers. And again, keep in mind that it has to be a primary duty. So this can be complicated if you have a fairly hierarchical business structure where there's kind of a big org chart that's not just vertical but more horizontal. It's often the case that folks a little lower on that org chart are thrown into this bucket when they shouldn't be. It's probably not often the case in nonprofits that we have the luxury of having huge organizational structures that allow for managers and assistant managers, but this is one that I think can be problematic in different ways in the nonprofit space, because you may have someone who does a small part of their job is managing a number of employees, but it's not really their primary duty. So that's where I've seen nonprofits get into trouble, is because folks are wearing multiple hats and it's not really a primary duty.
Sadina, we do have a question. Someone actually raised that situation of someone who their primary duty was a non-exempt position, but it was a school where they have an after school program, and they assisted with that in what would be considered an exempt position as a teacher in the after school program. So they're working 40 hours or 40 hours in a non-exempt position, and then they may work another 20 hours in an exempt position. What do you do with something like that, where someone is, clearly, they have split duties, part of which would be clearly exempt and part of which would be non-exempt?
I actually have dealt with that situation before. It was a few years ago, and I recall it being incredibly, incredibly complicated. And I think that ultimately what you have to keep in mind is that because of the primary duty requirements, you really do have to look at what the bulk of their work is set up to do. There are some unique exemptions with schools and around teachers, and so I think that's actually not a question that I can answer off the top of my head. I know that I've dealt with it. I know that there's guidance on it, but that's not something I would be comfortable giving advice on without looking into it a little bit further. So if you want to reach out to me, Regina, later on, and we can noodle over that, and you can get the contact information for the person who raised that question. We can see if we can come up with an answer for them.
Thank you.
And also, obviously, a gold star to the person who stumped me. Let's see. So let's move on to the administrative exemption, and I will try not to lecture too harshly on the fact that this is one that folks get wrong. I have done more wage and hour audits than I probably care to imagine at this point. I've been doing them for a very long time, and I have yet to come across a single employer of any size that is getting it 100% right when it comes to exemptions generally, and that doesn't have at least one, if not more, employees misclassified as exempt and on the basis of the administrative exemption. It's I guess good for my business, but it's really bad for employers, and it gives everyone a lot of heartburn. So let's talk about what you need to have to actually qualify for the administrative exemption. So again, there's the salary threshold, $455 per week. And here are the primary duties. It's non-manual work, so this is what we'd call a white-collar position, but that's not the end of the analysis. So it's not every white-collar position, but it has to be a white-collar position. It has to be related to running the business as opposed to doing line or manufacturing work, and it has to consist of discretion and independent judgment with matters of significance. So there's really two silos of analysis when it comes to the administrative exemption analysis, and this is where a lot of employers get hung up. It's not just that the person has to have discretion and independent judgment. They have to own projects or processes or what have you. They have to own things. But they also have to be with regard to matters of significance. So if you have a website designer and the discretion that they have is that they're choosing which colors go on your website, that is not a matter of significance. They might have full ownership over it, but it's not a matter of significance. You could have an administrative support person in your office whose job it is to make sure that everything is stocked and everyone is set with everything they need to do their jobs, and they have complete discretion to choose what company you buy the paper from, whether you go with Office Max or Amazon. That's not a matter of discretion. So it's those two, how those things align, that really gives a lot of employers problems when they're doing this analysis. When I'm working on a wage and hour audit, one of the questions I inevitably ask when I feel like someone is in the gray area, and the exemption in question is the administrative exemption, is what kind of heartburn does this person have at the end of the day? Like when they're on Metro at the end of the day and they are worrying about work, what kind of things are they worrying about? Are they worrying about whether they got this project in on time, whether they remembered to send all the bills out, whether they accomplished discrete tasks, or are they worrying about whether they made the right call when they advised a client about something, or when they made a decision that had an impact on the finances of the company, or if they made a decision about how the organization should be structured, or strategy, or fundraising, those sorts of things. I have found that asking the type of heartburn an employee has with their position is a good way to kind of cut to the chase of what types of issues are they really, really owning. So the issues here are that this had been seen for a long time as just kind of the catch-all, right? That as long as someone's white collar, as long as they receive a salary, that means they're exempt under the administrative exemption. End of analysis. Not so. As I note here, this has been significantly limited by particularly plaintiffs' attorneys in the last 20 years. There was a long period of time, I would say definitely in the 70s and 80s, no one really paid attention to this at all. And then class actions started to become much more popular, and plaintiffs' counsel realized that there was a real opportunity, or a real disconnect between the actual practice and the statute when it comes to what you need to have to actually meet the administrative exemption. Some interesting things to note about the administrative exemption, and one that hopefully resonates with folks on the call, is that, for example, the Department of Labor has made clear that paralegals do not meet the administrative exemption. Paralegals are not exempt unless they, for example, have like a PhD in chemical engineering and they do patent work, and that PhD is important for their analysis of the patent proceedings. But generally speaking, paralegals who are incredibly important to the practice of law and to the operations of businesses and to work that goes on in legal departments in-house, they're making decisions, but they're not of ultimate decision makers, and they're not matters of significance. So I think that's an example of the type of employee that you might otherwise think would qualify, but actually does not. I'll also note that.
I was going to say,
yes,
Sadina, I just want to raise one thing I asked you about yesterday, which is, sometimes you may have a senior person in your, say, finance department, a senior financial accountant or something like that, and then you have an entry-level junior accountant who will eventually train up to be that senior person. Just because their career progression would take them to a professional or administrative exemption doesn't mean they start off that way, I think, is where we left it, correct?
Yes, that's absolutely correct. It's really important, and it can be challenging when you have folks who are in, pretty discrete departments like that typically, finance or those sorts of things that are otherwise going to be exempt positions. But just because you have someone who's a junior level person who's doing some of the underlying research and work and data entry and some low level analysis as they start their careers and they begin to learn what it means to work in that field, you really do need to do an analysis of the tasks that are performed as a part of that job and figure out if those tasks meet the exemption. Another point that you and I discussed, Regina, when we were chatting yesterday, was that it's important to keep in mind while you're doing that analysis that you're analyzing the position and not the individual. So you could have an entry-level person who is a total go-getter and who is brilliant and is going to be a superstar, and you think has the potential to go all the way to the top in your organization. The fact that they're ambitious and smart and they go above and beyond does not make them exempt. It's the nuts and bolts of what they're actually doing. So it may be that person rises through the ranks more quickly, and as Regina gave an example, rises from a staff accountant to a full-fledged accountant more quickly than you would expect. But the analysis really is what are the tasks associated with that position. And I'll also note that this is why it's super important to have standard and accurate job descriptions for each of your positions. It's really important to make sure that those job descriptions are tracking what folks do for a couple of reasons. First of all, if heaven forbid you're looking at an audit or litigation, you have that documentation that shows what the basis is for your analysis and for your determination that the position is exempt or non-exempt. The second thing is that it's a good, I find it's very useful as an annual review process touch point, right? So if you have an employee who is that super ambitious superstar and they're doing great work and they're growing out of their position, reviewing those job descriptions annually is important because it can help you determine, you know, is it appropriate to promote this person into a different job with different job tasks? Are these other tasks below them? Who should be performing those tasks? So as part of your kind of more holistic analysis of your operations and what folks are doing, it's very useful. Also super important in litigation. So let's see. I was about to move into the outside sales exemption. Let me see how we're doing on time. I will move fairly quickly through this one since we are approaching the end of our hour, and I doubt that folks have this one, any employees who follow on this exemption. This one's pretty straightforward. It has to actually be outside salespeople, and they generally are not they're not paid a salary, so it's a pretty discrete type of workforce that would apply for this exemption. The computer professional exemption, I would say you have here the primary duties. It has to really be nuts and bolts computer stuff. Usually when I'm doing a wage and hour audit, if I don't understand what the person is doing, that's a good sign to me that it's probably going to meet this exemption because it's so technical that it really is getting into the weeds. One thing I'll note here in terms of the ripeness for errors is that if you have someone who's a help desk employee or who's generally assisting with technical stuff but is not making decisions about your systems, the design of your backup procedures, working with folks in your organization to figure out what their software needs are, they're really just troubleshooting and helping out and providing support, that is not an exempt position, and that's one area where I've seen a lot of errors. The highly compensated employee exemption is an interesting one, and it really changes the analysis for the executive and the administrative exemption in terms of how much of a person's job needs to be spent on those duties. So with those two exemptions, an individual's primary duties have to be performing exempt work. So their primary duty has to be managing people. Their primary duty has to be taking ownership of parts of the business that are of significance, right? For the highly compensated employee exemption, if you have someone who's making over $100,000, they really only have to be customarily and regularly performing at least one of the descriptions. They have to be doing primarily white-collar work, but they also do not have to meet that primary duty requirement for the type of exempt work that they're doing. So if they're spending 20% of their time managing and the rest of their time doing non-exempt work, but they're paid over $100,000, the Department of Labor doesn't care, and individual plaintiffs' lawyers don't care. This is an area that you rarely see litigation for overtime pay for someone who's making this much money anyway, but definitely worth mentioning. I also want to note that not all states recognize that exemption. So if you are, I think Pennsylvania is one of them, if you have folks in different states and that's your basis for an exemption, just be sure to check that the states you're in recognize that exemption. The professional exemption, this is one, again, that's not terribly ripe for errors. It requires advanced degrees, advanced knowledge. Lawyers, but not paralegals, are included in this. In the medical field, in accounting, if there's specific types of accountants. I know we gave a staff accountant example previously, not an entry-level staff accountant, but there are certain areas in which there's a general understanding that those folks are professional and so they're exempt. I will say that on that front, the Department of Labor has issued throughout the years a number of opinion letters that speak to specific questions that employers have posed. It was a practice that the Obama administration stopped doing, but my understanding is that the new administration actually is going to take that back up, which I actually think will be really helpful because I often refer to those opinion letters, for example, when I'm trying to figure out like what type of accountants are exempt or are paralegals exempt? Answer no. So those opinion letters are really, really useful, and they're pretty well organized on the Department of Labor's website. I don't think that we have...
yes. The now defunct overtime regulations. I get a lot of questions about registered nurses, licensed social workers, MSWs, people like that, whether they are considered professionals. I know there's a lot of, work in this area about whether an RN as opposed to an LPN and stuff like that is exempt.
Yeah, it's the analysis is very, very fact specific, and those are exactly the situations where I go to the Department of Labor opinion letters. There's case law out there as well, but for most of those, you can look at the opinion letters, and they'll draw those distinctions. I don't happen to know those distinctions off the top of my head, but they because they're pretty common distinctions within those professions, those are questions that have been posed to the Department of Labor, and they've taken the opportunity to issue their opinions on it. If it's no longer their opinion, they'll withdraw them, so you'll know if the opinion is still good, and you can still rely on that. But it's my first step for those types of questions is always the opinion letters on the Department of Labor's website.
Thank you.
Okay. Okay. Well, I see that we're running very low on time. So I've mentioned the defunct regulations. I won't spend too much time on that because there are a couple other issues I just want to flag for you. That resources I've included here. That's some update on the litigation. You're welcome to read it. Interns and volunteers are something that a lot of nonprofits get in trouble with. There are very, very limited circumstances in which any employer can have an unpaid intern. For-profits, basically never. Nonprofits, still almost never. So if you are a nonprofit and you have unpaid interns, this is really something you need to be paying attention to make sure that you are not running afoul of not just overtime rules, but minimum wage rules and all the whole host of employment laws that are center on wages. So I flag that as a potential landmine. I have referenced here the Department of Labor fact sheet that speaks to this. A great reference on the Department of Labor's website, in addition to those opinion letters, also are their fact sheets, which cover all the exemptions, and they're actually incredibly well done and very, very helpful. So if you have questions, that's also a good resource to start with.
Can I just say we also have a podcast on that, on the skinny on summer interns, and when we send out the evaluation, we will include a link to that podcast just because it goes through a lot of the issues about summer interns. Great,
that's excellent.
Thank you.
So another potential landmine is independent contractors versus employees. This is, something I also could speak on for 3 hours if given the chance. There's a lot of room for error here, and I definitely have some of my nonprofit clients who have decided to use contractors on, a 6-month basis or a year-long basis, and have thought that because they have a discrete contract with the person and they're only coming on board to work for a specific amount of time, that means they could be a contractor paid by 1099 instead of an employee. That's not the case. It's a much more robust analysis. Again, we don't have time for that, but something to keep in mind is a potential problem if you have folks who are kind of kept on a contract basis, that you need to really take a hard look at that and make sure that you are not inadvertently failing to not just, again, pay overtime, but unemployment compensation and all sorts of issues that go along with that. I have in here some of the
big one too.
Yep, absolutely. There are a lot of issues here. So I have in the materials an overview of some of the analysis to be considered. So with that, I have raced to the end with 1 minute left.
And then we have a question for you. So
Great.
We have the case of an employee who is given the title of assistant director or associate director. And while they generally oversee the work of some people, 1 or 2 people under them, they're not their official supervisor. I guess it means they don't do the performance appraisals and stuff like that. But they are directing their day-to-day activities. So they don't have a lot of discretion to make big decisions. Again, they make the day-to-day decisions like, shall we get our office supplies from Office Depot or Staples, or how much is it time to order stuff and things like that.
Mm-hmm.
Exempt or non-exempt?
I would say that's definitely in the gray area, and I would have some heartburn, short of beefing up some of their duties and determining, whether they should have more rigorous management responsibilities for those other folks than they have now, before I would be comfortable saying for sure that that person is exempt. Certainly the job title sounds exempt, but when you actually look at the tasks, if they're not really making significant decisions or owning processes or procedures and issues that are really speaking to the management of the significant issues of management of the company, that could potentially be a problem. It's often this may be a case too where you have someone who is in the position and is not performing those kind of higher level, harder exempt tasks because either they're not being they don't have the capacity to do so, they're not comfortable doing so, they don't want to do so, so they're not really performing the tasks that otherwise would be associated with that position. And if you had the best possible candidates, or maybe that others are just kind of holding them back inadvertently, but this person really is capable of it. So oftentimes the analysis is not just, okay, well, what are they doing right now, but what should this position involve, and are there reasons why this person isn't performing exempt work? Is it because of their performance issues? Is it because other managers aren't giving them the leeway that they really should have? And using this as an opportunity to figure out if this person could step into an exempt role. So it's not necessarily a huge, well, it could be a problem if they have not been doing that, and obviously they have not been paid overtime in the past. But in terms of how you manage it moving forward, it actually can be a positive thing in terms of helping someone, step into their next role, grow professionally, and to maybe take some weight off of other leaders within the organization who can give that up, and it's appropriate for that position.
Okay, and one final thing, it's their duties, not their job description. So if their duties are different from the job description, they should update the job description?
Yes, absolutely.
Okay, because and this is not a static analysis. I think we talked about this yesterday. Mm-hmm. If someone's been in a position for 5 years, their job duties may change over time. They may assume more managerial responsibilities, or their duties may be assigned to somebody else. So this is, you have to go back and revisit these issues from time to time.
Absolutely. And like I said earlier, I think that during an annual review process is a great time to take a look at the job description, to lead the conversation. What have you been doing tasks that are completely different from this? What does that mean for your role? What does it mean for these other tasks that at some point we thought were important enough to put in your job description, and to really have that ongoing dialogue so that, the employee knows what's expected of them. Everyone else knows what the employee is going to be doing, what their focus is. It just keeps everyone on the same page. So in addition to being a prophylactic against getting yourself in trouble in litigation, I think in terms of employee management, which is obviously not the topic of this conversation, but I think that there's some overlap there, and you can use that otherwise maybe annoying process of updating job descriptions as part of a more meaningful process around duties and tasks and expectations. Okay.
Well, with that, thank you for everybody for listening in. Again, I apologize for the sports talk that you inadvertently heard. I didn't realize everybody could listen in. So thank you. You're getting a follow-up email with a link to the recording of this webinar and an evaluation. And as I said, before you log out, don't forget to download the handout, and we will send you the link with the information that we talked about on summer interns. So thank you, and have a great afternoon, and thank you, Sadina, a great webinar. Thank you.
Thanks, everyone. Have a wonderful day.